Hi, good afternoon, everybody. I think we should start, although I think there's some more people to be joining shortly. My name is Tony Grundy. I'm the co-chair of the Legal Services Interest Group, and it's my pleasure to introduce Meryl Koh, Director of IP and Dispute Resolution at Drew & Napier, to present the second in a series of IP-related webinars to keep you up to date with the landscape in Singapore, as Singapore seeks to develop its role as a global IP hub in Asia. We're also going to touch on IP disputes, and in particular, a less traditional mode of dispute resolution for IP, that is arbitration. Meryl, I'm pleased to say, is a very active member of the International Chamber's Legal Services Interest Group and also of the Circular Economy Interest Group. Meryl acts for clients in contentious IP matters in various industries, including media, esports, tech, F&B, pharma, and manufacturing. Meryl also has an active court and arbitration practice in matters concerning contractual disputes, defamation, breach of directors' fiduciary duties, and employment law. Meryl is recommended in various legal ranking publications, including Legal 500, Who's Who Legal, Asian Legal Business, and the World Trademark Review 1000. Meryl is professionally qualified in Australia and Singapore and was appointed to the panel of experts for WIPO, Fast Track Intellectual Property Dispute Resolution Procedure for Consumer Affairs. Meryl is also a fellow of the Singapore Institute of Arbitrators. My role as moderator, I think, will be a sinecure because I'm going to hand over the chair to Meryl. It says on my briefing notes I should next talk about housekeeping statements. But I think over the last 18 months, we've all had so many webinars that that's not necessary. But please, at any time, if you have any questions, put them in the Q&A box and we'll do our best to answer them. With that, I'll hand over to Meryl. Meryl, please.
Thanks, Tony. Thanks very much. Good afternoon, everyone. Thank you for joining us on a Friday afternoon. I'm sure you would much rather be doing something else, but I'll promise you that I'll try and make this as painless as possible. Then we can get on with our happy hours. All right. So as Tony mentioned, this is the second of a series of IP-related webinars that the SICC has so kindly allowed me to share with everyone. I'll just go into where we left off in the last seminar. So in the last seminar, we went through the basics. Essentially, it was called IP 101 to talk about what the different types of IPs are. And this was one of the final slides of that presentation. I'm sure the recording is available on SICC's website. But essentially, I spoke about the fundamentals of the common types of IP being copyright, trademarks, patents, and confidential information. Designs is another pretty common one, but I think from a more commercial standpoint, designs are a little bit more technical, and it usually comes as sort of a second tier IP in terms of popularity. I also spoke about what these IPs were, how to find or discover whether you have such IP in your business or in your client's business, and also how to best protect or enforce them. All right, for today, I wanted to make it more practical. In the news recently, you might have seen that Singapore is really making huge strides in trying to, or continuing to try to be the IP hub in the region and actually globally as well. So today I'll talk about three main topics. The first one would be Singapore's evolving IP landscape, basically just to see where we are. I will also talk about the Singapore IP Strategy 2030, as well as relevant legislation that has come out of that. The second section, I will go a little bit into dispute resolution. That's my area of practice, but it's also interesting to see how that has developed in the IP field, because generally for intellectual property, disputes are dealt with at the respective national agencies or in the national courts. It is less common to see pure IP disputes being dealt with in arbitration, but this is something that is up and coming, and Singapore in particular has made it a focus recently. The last point is on negotiating IP contracts. So I've made this a little teaser as a lead up to perhaps further webinars that we will have together with the SICC's Legal Services Practice Group, Interest Group, if Tony would have me. But I've set out a few points here in today's presentation so that you can take that away and have a think and maybe join us the next time. Okay, let's go into it. So quickly, I wanted to first grab your attention, hopefully, with some rather important statistics about, well, basically to show you that if your clients or your own business has not shifted its focus to exploiting and protecting your intangible assets or IP, then you should as soon as possible. Because the world obviously has become increasingly globalized and digitized, and IP continues to be a key driver of economic growth and is proving to be a very significant part of local and global markets. With this financial promise, of course, it comes the potential for legal disputes, which is why the next section we're going to talk about dispute resolution for IP matters. But otherwise, it is important for businesses to seek to set themselves apart from the rest of the competition by leveraging on innovation and creativity and distinctiveness in your business. If you look right here on the left, we have recently reported numbers about global intangible asset value. So this is up to US dollars 65.7 trillion. And in terms of how much IP is being traded, global payments for the use of IP around the world is 629.1 billion US dollars. So that is obviously a very large amount because it represents 7% of global import of services. Where does Singapore stand then in the global scene? Some notable accolades. We are top 5 since 2015 in the World Economic Forum's Global Competitiveness Report for IP protection. Top 10 since 2010 and 8th in 2020 for Global Innovation Index overall rankings. The data is all there. First in innovation input, second in investments, and 6th in IP payments. And it's the 3rd most preferred seat of arbitration in the world. And SIAC as an institution is the 3rd most preferred arbitration institution in the world and most preferred arbitration institution in Asia. So that has been in the news recently as well. So I'm sure many of you who are in practice will be aware of that. So something to be very proud of, obviously. So I set out here also some data which my team has helped me put together in very nice graphs. These are all information that you can find from IPOS, but not in graphs like that. They're all sort of in charts, but we've put them together so it's easy for you to see. In my earlier seminar, I had mentioned that not every type of IP is registrable or needs to be registered before you can use or exploit it. For example, in Singapore, copyright is not registrable. So you're talking about your media content, software codes, and copyright is protected by keeping good records of your ownership and your creations. Trademarks, patents, and industrial designs, as shown here, are registrable, and generally one of the best ways to protect them is to file for an application for registration. That said, since registration is a pretty much very straightforward way of proving your ownership in a particular IP, the trends and numbers in these IP filings in Singapore will certainly tell the story. We will discuss more about the Singapore IP strategy and master plan, but some things to note from these numbers is that since the publication of the IP Hub master plan in 2013, patent, trademarks, and industrial design filings grew between 3 to 6% respectively. And more importantly, local applicants for patent and industrial designs filing grew at what IPOS calls a remarkable amount at 10.8% and 9.5% respectively. So it does show that with the government's active input and driver towards more IP filings and bringing innovation to Singapore, local SMEs and businesses are sort of jumping on the bandwagon to recognize the value in their IP. So it's not just the MNCs with deep pockets that are doing it anymore. And generally, there's been a significant growth in Asia, where in 2019, of all the patent applications filed worldwide, 65% of it came from Asia. I would imagine that a lot of it is going to be related to fintech and all your new tech that's coming up. But 10 years ago, it was under 50% for Asia, with Europe and US being the leading jurisdictions. Before I go into the next slide, I thought that in case you were interested, the common industries that file trademarks, patents, are actually not the same. So for trademarks, the top industries are companies that deal with goods and services in scientific or photographic or consultation sort of businesses, and education as well. So that is fairly constant. That has been fairly constant for Singapore from 2015 to 2019. For patents, the most common industries that file applications for patent registration are chemistry and medtech, healthcare, and human necessities. And also a lot of technology relating to physics, which is probably more for the manufacturing industry. Overall statistics aside, there's also been a huge focus to encourage new and green tech patent filings, with IPOS launching the SG patent fast track in May 2020 and the accelerated initiative for AI technologies. These schemes are actually meant to benefit innovators who have invented or work with inventions which are very time sensitive. So for example, those that have massive social impact, green tech, those relating to sustainable food production, waste management, and also those that have a healthcare impact. So obviously with COVID-19, things like ventilators and diagnostic kits and tracing apps and digital health solutions. So all of these type of technologies have a sort of a privileged fast track with IPOS for patent filings. The other emerging technologies as well would be fintech, AI, artificial intelligence, and also Internet of Things. So these technologies have a very short shelf life. They put it out there, within 6 months, someone else comes up with something new. So it was very important for IPOS to come up with a scheme to allow patents like that to be filed and registered quickly. So I think one of the first patent filings that went through took under 6 months, and normally it's about 2 years. So this scheme has proved to be very effective. On the next slide, I put out some numbers about disputes on IP issues. You can see the breakdown on the slides, and perhaps when you after the presentation, you can take your time to have a look at it. But so these generally just show a general upward trend on absolute numbers for IP disputes year on year. That will be quite logically in line with the increase of IP filings as discussed before. Interestingly though, there's actually not that many cases. If you look at it, they're sort of double, sometimes triple digits, but most of it, I feel, this is my personal opinion anyway, is that Singapore as a jurisdiction is not the most litigious as other IP powerhouses like US or Europe. So that might be the reason why the number of disputes that for IP matters that end up, especially in court, are not staggering. In the past 5 to 6 years, however, with trademark disputes before the IP office has been quite consistent in that if there are about 100 applications for trademarks, of course there are way more. If there's 100, about 60 to 80 of those applications will find themselves in some sort of dispute, so either an invalidation or an opposition, but that's before the IP office. All right, now I will just talk a little bit about Singapore's IP strategy. So this started, as you can see from the timeline at the top of my slide, in 2013, where the government published the IP Hub Master Plan to develop Singapore as a global IP hub in Asia. And the focus was on 3 things. 1, they wanted to make Singapore a hub for IP transactions and management. 2, as a hub for quality IP filings, and also a hub for IP dispute resolution. So all of this come hand in hand. I would imagine it's one big hub as opposed to 3 little hubs. But In 2017, this was updated following the release of the report of the Committee on Future Economy, which contained economic strategies for Singapore's growth in the next decade. So needless to say, the importance of the important role of IP as a way to support innovation and technology transfer into the country was highlighted. The 2017 update to the IP Hub Master Plan then contained or highlighted 3 key objectives. One, so it's meant to be sort of a subset of the original higher level master plan. But what is obvious is that the focus is not dwindling at all. The first objective on the update was to grow local IP expertise to help enterprises manage and commercialize their IP. Number 2, to enhance Singapore's IP and innovation ecosystem. And 3, to create an effective marketplace for IP. Maybe just to briefly talk about where we are now before I go into the what was covered in SIPS 2030. As mentioned earlier, there has been an increase in IP filings from local and regional applicants. And I think there's a notable increase after the launch of the IP Hub Master Plan. Personally, I think a lot of it is that the market is being educated about the value of IP, with a lot of emerging technology coming up and a lot of focus on intangible assets. Besides the increase in filings, IPOS also launched a Go mobile app in August 2019, which is really a very, I've tried it before. It's a very user-friendly, easy app to allow business owners to easily access their IP portfolio, renew and file their trademarks, and also conduct searches. So filing becomes cheap and easy and very accessible, so it's no longer intimidating for business owners or SMEs. There have been various strides made to increase the patent search and examination capabilities at our IP office. And there have been a slew of various educational and training certifications to boost IP manpower, including the Singapore University of Social Sciences Master of IP and Innovation Management. They're all mostly subsidized by the government and very accessible as well. In terms of IP dispute resolution, we now have a specialized panel of IP judges at the High Court. There was a launch of an IP court guide. So we all know, or maybe a lot of us know, that the Singapore civil procedure is governed by the rules of court. But the IP court, or the IP panel itself, has had come up with their own IP court guide as well, because there are certain intricacies in IP litigation that is quite different from the normal corporate commercial litigations. WIPO, the World Intellectual Property Organization, they've also opened up their Mediation and Arbitration Center in Singapore, which is the only office outside of their headquarters in Geneva. And we also have a specialist panel of IP arbitrators at the SICC. IPOS has also launched very successful IP legal clinics and various IP mediation promotion schemes, and as I mentioned earlier, the fast tracks for specific types of patent applications. Having developed capabilities and infrastructure to support IP activities, obviously Singapore's next goal is to really become a leader in this area. So that's the focus of the Singapore IP Strategy 2030. The 2 objectives is to continue to grow Singapore as a global hub for IP activities, and to maintain Singapore's top-ranked IP regime in order to instill confidence in investors and innovators. So the idea, obviously, is to just attract innovation and technology into Singapore. I hope this is not getting too dry for everyone, but I suppose if you listen to what I'm about to go through, it will save you the trouble of reading the 30 to 40 page document that the government put out. So SIPS 2030, the government, the team the committee that works on SIPS 2030 came out with 3 interlinked thrusts. The first one was to ensure a world-class and forward-looking IP regime in Singapore, to develop Singapore as a node for ASEAN and the world, and to position Singapore as a choice location for international IP dispute resolution. The first 2 are a lot quite similar to what has been done before, but they're moving at a much faster pace and sort of pushing everything a little bit more. So, for example, improving the systems at with IP filings, education of the industry. So it's not just lawyers that know about IP. The one that obviously interests me the most, because again, it's my practice area, is the fact that the Singapore government is pushing, and this has come out in legislation as well and several guidelines, pushing Singapore as a choice location for international IP dispute resolution. The reason why this is interesting is because intellectual property and IP law is generally jurisdictional. So any fights or infringement or any disputes about validity of a particular IP or ownership is always locked into a particular jurisdiction. So if you have a Singapore patent, everything about it will be done in Singapore. But obviously there's, as I mentioned earlier, there's so much globalization. There's more and more need for cross-border dispute resolution for IP. So here I will focus at this point. So I mentioned the first 3 points here about the specialist list of IP judges, WIPO Arbitration Center, and the specialist panel of IP arbitrators. But I'll go a little bit more into the Intellectual Property Dispute Resolution Act on the next slide. So this IPDRA, as you can see here, was tabled in July 2019 and was partially commenced just a few months later. Clearly, there was a real need to cement in legislation what was already in practice in Singapore. And it was meant to send a clear message that Singapore is well equipped to deal with IP disputes, both in courts and via arbitration. The two key objectives, as you can see from the left column, is to strengthen Singapore as a venue for international IP arbitration and to ensure cost-effective resolution of IP disputes. So this is fairly generic, right? Every new dispute resolution regime is going to want to focus on being cost-effective and being able to handle cross-border issues. The difficulty with IP disputes is that the general consensus is that, IP disputes must be dealt with by the national courts, because the court will have to give an order for the validity or infringement of a particular IP, and then the national agencies or the local IP officers have to sort of implement it, take it off the register, allow amendments to be made to the registration, etc. So there's always been this doubt that arbitration could be something that is used for IP disputes, because as most of you might know, arbitration is only binding between the parties who are parties to the arbitration agreement. So where is the power in the tribunal to bind national agencies or to cause any effect on third parties? But there is actually some commercial benefit to that. So the first thing Singapore did was to confirm in legislation that IP disputes are arbitrable, and that arbitral awards on IP issues are enforceable in Singapore. The third point here, which is out of my little yellow block, is that we've consolidated most civil IP disputes to go up to our Singapore High Court. So it used to be sort of a split system where depending on which, this gets a bit technical, but depending on which cause of action you wanted to start in an IP dispute, you could start it at the IP office or the High Court, or sometimes there might also be parallel proceedings depending on which IP you're talking about. But so it was actually a much needed relief that the legislation has now pushed almost all civil IP disputes to the Singapore High Court, where we already have a specialized panel of IP judges. It's just clearer and easier for everyone. The specialist track for IP litigation in the Singapore High Court is a good one as well, because with any IP dispute now that started at the Singapore High Court, you have a particular group of registrars that will handle the pre-trial conferences and the case management conferences leading up to trial. Again, as I mentioned, there are many nuances with IP disputes that are quite different from the usual litigation. So it was important for the court to have that feature in the new system. All right, so okay, before we go to the primer on dispute resolution, I also should mention that the IPDRA, so the IP Dispute Resolution Act, also brought with it consequential amendments to the Singapore Arbitration Act and the International Arbitration Act. So it's just beyond doubt that IP disputes are arbitrable in Singapore. Sometimes I feel personally that's a bit of a marketing point, but important, because I mean there are going to be cross-border issues from people from other countries that are not familiar with the Singapore legal system and probably had no idea that IP disputes can be dealt with by arbitration in Singapore. So putting in legislation really makes it clear. Okay, so in this slide, I just wanted to set out some high-level features of litigation, arbitration, and alternate dispute resolution methods. I'll just put aside for now the common disputes that I mentioned earlier that usually happen at the IP office level. So things like oppositions or invalidations, those are usually directed at registration. So the disputes that I'm referring to here are those that are probably more related to infringement of IP or IP contract breaches, etc. So these features are quite common in matters that don't involve IP as well. So you would know that litigation is a sort of a default way of resolving, or not resolving, but commencing a cause of action in order to enforce your rights, including IP rights. It's adversarial, it's decided by a judge, it's final and binding, but there are appeal avenues. It's structured, so those who like structure and like certainty, litigation is probably the way to go. It's one of the important differences is that litigation is obviously generally public, and the court can make orders which are binding on national IP agencies. For arbitration, however, it is based on an agreement to arbitrate. It is also adversarial, decided by arbitrators, which in a way is good sometimes for IP matters because you can appoint arbitrators who have specialized knowledge. They're also final and binding with very limited appeals, but the procedures are flexible. And if you're a practitioner in arbitration, you will know how flexible these procedures really are. And it's confidential. And it's generally binding between parties only. So, for example, if you had a dispute concerning the validity of a patent, if it's dealt with in arbitration, it will only be binding between the parties. So, for example, party A will say to party B that your patent is invalid, so you can't sue me for infringement. Then party B will just say, okay, fine, I can't sue you for infringement because that's what the award says, but that patent is still subject to the usual rights outside of the two parties. So third parties are not going to be touched at all for any awards on IP disputes in arbitration, unlike in litigation. So if in litigation, if there was a patent that was found to be invalid, it is taken off the register, and third parties can't be sued, or that patent can't be enforced anymore against third parties. For mediation, conciliation, and neutral evaluation, these are generally meant to be more conciliatory, and they're generally confidential, but not necessarily binding unless you come to a settlement agreement. Even then, enforcement probably involves another layer of litigation or arbitration or mediation again. Negotiation obviously is kind of a go-to in commercial situations, especially with the costs, the massive time and cost that will go into complex IP litigation, which almost always involves technical experts and multiple technical experts, huge amount of discovery and documents. So litigation or even arbitration might be a measure of last resort. However, because of the flexibility of arbitration, it's gaining a little bit more prominence and popularity. And one big pro for arbitration in IP disputes is the cross-border effect. You can have various IP filed in various jurisdictions dealt with in one arbitration. If you were in litigation, that would probably not be possible. Okay, so this is just a slide that I put up, which sets out the pros and cons of the various avenues of dispute resolution I spoke about. And I think most of this I've already gone through earlier. Okay, so I think it's pretty much self-explanatory. One thing that I must say with litigation is in terms of optics and public vindication, so this first plus, some people see it as a negative. For example, if you were a startup trying to promote your new super app, being in public litigation may or may not be good. Or actually, if you think about it the other way, if you were a big player in the super app market and there was a a new startup that is coming up against you, for example, for trademark infringement, the big player may prefer arbitration so that they don't take the risk that they might lose to a little startup. But the startup might enjoy the publicity of going up against a Goliath. So it really depends on the parties or the subject matter. As I mentioned earlier, the key issues with IP disputes when it comes to litigation versus arbitration is the effect on third parties and cross-border issues. So on this last point here, for litigation, one of the biggest issues is trying to figure out whether or not a court order is going to be easily enforced in a different jurisdiction. So generally, for example, for patents, usually people who are businesses that are expanding are not only in one jurisdiction. They're going to be in various jurisdictions in Europe, in US, in China especially, and in Singapore, or in various jurisdictions in Southeast Asia. Having just a court order from Singapore to stop infringement is not going to be very useful if the infringement is overseas or if the infringement is all over the world in various countries. So sometimes arbitration is a much better avenue for dispute resolution. But again, it may not be a matter of it may not be the choice of the IP owner to decide on which is the best dispute resolution method, because again, arbitration and any mediation or neutral evaluation has to be by agreement. Perhaps maybe at this time, I should briefly talk about the types of IP disputes that would benefit from mediation and negotiations instead of litigation or arbitration, since I sort of touched on it a little bit. So in cases where litigation would be too costly to make sense, especially, I like to use examples from startups because I do have a lot of clients who are in that field now. So they're all starting up with a little bit of funding, trying to build an app or trying to build some new IP. And they don't want to go into litigation, but it's because it's too costly. So mediation would be one of the better ways to deal with disputes. Or when disputes concern IP rights across multiple jurisdictions, as I mentioned, mediation might be better. Because then you can have a holistic agreement. So it's going to be very commercial, where parties will say, okay, you can have certain jurisdictions, I will have the other jurisdictions, or you can have certain goods and services, or parties can agree on royalties, licensing agreements, etc. So it becomes very flexible. When the parties want to keep the dispute confidential, mediation would be great as well. Where they need a flexible commercial resolution, as I mentioned, a coexistence agreement can be a good solution for a dispute. Collaboration, licensing, as I mentioned, and also where the traditional legal remedies like injunction and damages do not necessarily afford the best outcome for the winner. Also, when time is of the essence, sometimes litigation and arbitration can take too much time. It may very well be that a quick mediation, a very commercial sort of conciliation or negotiation will work better for parties. A little side note on developments for IP litigation. As I mentioned earlier, generally there's a lot of people that favor arbitration for its sort of flexibility and cost effectiveness. And the traditional view is that litigation in courts are very expensive and not cost effective and takes such a long time. So with that, in Singapore, there has been a big push towards civil justice reforms. The rules of court are being revamped by the Ministry of Law, and they are aiming to have these enforced by the end of this year. The ideals that they have focused on are fair access to justice, expeditious proceedings, cost-effective work proportionate to the nature and complexity of the dispute, efficient use of court resources, and fair and practical results. So, for example, there is a much greater focus on early ADR. The courts will actually put some pressure on parties to make an offer for amicable resolution before commencing action. And I think there's also some proposals for parties to have to explain why they have not made any offers for amicable resolution prior to commencing proceedings. So that's quite interesting to me, because usually when you go into litigation, parties are acrimonious and they probably hate each other's guts. No one's going to try and put in an amicable resolution offer, but now the courts are the ministry is pushing for parties to make that priority. The other thing which I found quite interesting as well is that AEIC, so affidavits of evidence in chief, these are your witness statements that sort of form the base of your evidence for trial. These may be ordered at an earlier stage, for example, at the same time as discovery. This is to encourage more upfront assessment of merits instead of only sort of holding your cards close to your chest and only seeing everyone's cases at the doorstep of trial. So that again is very interesting to me. So it's a huge revamp in my view on the rules if all of this goes through. So we'll see how that pans out. There has also been, this is not in the slides, but I wanted to mention as well, there has also been a lot of work going on to revamp the key IP legislation to make it easier to understand and easier to implement. The Copyright Act, for example, is undergoing a huge revamp to give local creatives and artists clearer rights over their work. So the aim is to make it much more layman, easier to understand, and not so complicated where all the various rights are split up in 5 different subsections. So that's also something that's coming up, and I understand that from the Law Society committees that's also going to be pushed for the other IP legislation for patents and for trademarks as well. So that's going to be a welcome relief for IP practitioners. All right, so on this slide, I put out some questions that you might ask before commencing any action. Your clients might ask you, you might ask your clients, or if you run a business and you want to deal with IP disputes, you will ask yourself. So things like, do I have legal standing? That would be, are you the owner of that particular IP right, or are you an exclusive licensee? Do my claims have merit? Obviously, that touches on whether you have evidence. Did you conduct a track purchase to understand whether or not you actually have a claim for IP infringement? Is my threat groundless? The reason why this is important for IP disputes is that under the various IP legislation, if a party thinks they have a right to sue someone for IP infringement and sends letters of demand saying that you've infringed my patent or copyright or trademark, but they don't actually have a very good case, or they don't have a case at all, so it's fairly frivolous, or there's no real basis to it, and the receiving end, the receiving party actually makes a loss in its business. For example, it got a little shaken by your letter of demand and then stopped manufacturing certain things in order not to infringe your alleged rights in a certain IP. But if it turns out that you don't have a case, the receiving party can actually sue that alleged IP owner for groundless threats. So basically it's saying that you can't, the idea is that you can't go around alleging that you have IP rights unless you actually do have IP rights. So that's something that is quite unique to IP disputes. Should I sue? These are pretty logical questions, but I guess when parties are in dispute, sometimes they don't have the logical frame of mind to sort of consider all this. What do I hope to gain? Do I want damages? Do I want an injunction? Do I just want a moral victory? Do I have the time and resources to put into litigation or arbitration? Or is it better to just try and negotiate? Does the other party have resources? So the David and Goliath situation. Is ADR an option? So for example, if you are thinking of perhaps going into collaboration with that other party, you have a long-standing licensing agreement, maybe ADR will be much better than going to litigation. Is the other party even receptive? Because obviously if you want to go into amicable resolution, the other party has to also engage and agree. Is arbitration an option? So you have to look at your agreements and your contracts to see whether parties had already agreed for a certain dispute or scope of disputes to be covered by arbitration. So all these are just various questions that one would need to answer before starting any action. The other questions are also really important, and we can see there's so many questions that have to be answered, but these are just important pointers to consider. Where do I sue? First of all, are there any contractual clauses that apply? So these are dispute resolution clauses and also jurisdiction clauses. Which forum is convenient? And convenience usually is considered by where the wrong has happened. So the common ones are where the wrong has happened, where the infringement is, where the infringer is, where the most important market might be, where the witnesses might be. So these are various considerations that will come in for in considering which forum is most convenient. Where's the other party located? Where are the other party's assets? So the reason why that is important is because generally when you start to when you want to commence litigation, you want to be able to enforce your judgment. So, and if there is an order for damages, you want to be able to enforce on it and get monies, right? You don't want to just have a paper judgment. So it's important to find out where the other party's assets are. If relief is obtained, are they enforceable in the relevant jurisdiction? So there are issues with registration of judgments, whether an injunction is going to be, or any preliminary relief is going to be enforceable in a different jurisdiction. So all this it sounds really complicated. It probably is, but once you get down to your objectives and find out where you want to hit that party for litigation purposes, it will probably be a lot clearer. The other thing on the right is, as I mentioned, what is it that we want out of litigation? Is it control? Is it optics? Is it saving costs, or you just want damages? So these are all important questions as well. I wanted to share about a matter that I'm dealing with right now. Obviously, I can't share the exact details, but it's an IP infringement matter where the plaintiff is based in various countries, but the target infringer is completely in China. So the reason why I say completely is that while that alleged infringer operates in various jurisdictions, it has no offices outside of China, but it has loyal followings and customers and sales all around the world because it's based online. So then there are all these questions concerning various complicating factors, like which law would apply, which jurisdictions should be the best place to start an action, depending on how the courts view the IP involved, where is the biggest damage in terms of infringement, where's the biggest market, and if it's always changing, then what is the best way to go about doing this? It has been sort of a very complicated journey for the client to consider where it's best to start proceedings. In fact, when it started proceedings in one particular country in the US, they failed on the ground of forum non-convenience, saying that, if you're going after an infringer who's in China, you should start proceedings in China. But generally, IP disputes in China are not, how do I say this without offending anyone? They don't turn out very well for parties who operate outside of the country. So I think there's a huge protection and a huge push towards protecting and pushing Chinese innovation. So there's sort of a little bit of difficulty in succeeding or getting any interim relief in China. I think that's a pretty common knowledge among IP practitioners. So this is something that was complicated. So all of these questions that are listed here are the very same questions I had to ask my clients, and my clients had to consider for this particular matter. So at the moment, there's no 100% like guaranteed solution. There's hardly even like an 80% guaranteed solution, but it depends on the client's preferences or where they want to go first. Then there are considerations on parallel proceedings and language issues, etc. So there's quite a lot of things to think about. Something else that I touched upon as well earlier was in terms of ADR in Singapore, besides having the WIPO Arbitration and Mediation Center right here in Singapore, the Intellectual Property Office of Singapore has also been pushing mediation schemes. These have been taken up quite readily because basically what they do with this enhanced mediation promotion scheme is that if you have a dispute before the Intellectual Property Office of Singapore, if you choose to go into mediation, parties agree to go into mediation, you can receive funding for admin fees, mediators' fees, and lawyers' fees up to 10 or 12,000, depending on what sort of IP rights are involved. And that's quite a lot of money. And generally, it can cover almost, for some smaller matters, it can cover actually all the costs that will be incurred. So from my experience anyway, almost all my clients take up mediation if there is a dispute at the IP office. The only sort of consideration they have to give to the IP office is that it is not fully confidential anymore. They have to agree to having an IPOS officer sit in to observe the proceedings and also write up about the outcome of the mediation. So it's not going to be fully confidential, but if that's sort of a small issue for your clients, being funded, I think, weighs much heavily in favor of mediation. So that's something that has been taken up very quickly by parties as well. Let me just see what the time is. Okay, so we're at 10 minutes. I wanted to leave a little bit of time for questions, if any, but just to go into this teaser section that I mentioned, because there's so much meat in the issues concerning negotiating IP contracts, and I know that there are some attendees here, and I saw the list, friends who are very well versed in negotiating IP contracts, so I wouldn't profess to say I'm a pro at this, but obviously I've advised on a lot of IP contracts and a lot of questions, and they're always the same questions that come up. And just for sort of your benefit, I've listed all of them in these two slides. These would cover situations where you're negotiating an IP-related contract from the start, so as part of your normal commercial business or as part of a settlement coming from a dispute. But the questions are all going to be the same. So for example, in general matters, as with all contracts, you have to consider who the relevant contracting parties are, what is the consideration, the governing law and jurisdiction, and this is going to be a little bit dicey sometimes for IP matters, and obviously the dispute resolution clauses. Then if it's going to be a commercial negotiation, a commercial deal, whether from scratch or, as I mentioned, from settlement, you have to consider whether the IP is going to be a subject of assignment or license. And in licensing, there's all these subcategories as well, whether it's exclusive or not, and what can you do with that license. So you kind of have to scope it out really well to be clear. So some key terms which I've encountered in my practice, and again are super common for trademarks, patents, and copyright. I've put them all there. They are self-explanatory. So for example, for trademarks, who is entitled to the goodwill from use of the mark? It may be parties that are outside the people who are actually signing the contract. It might be party A's distributors or subsidiaries, etc. So if it goes further, it should be stated what goods and services can the mark be used for. So that also has to be very specific. For patents, are you talking about a license or an assignment of the whole patent or only certain parts of the patent? Who is entitled to improvement? So someone can get sort of a seed patent of a particular technology and then improve on it. Who gets the rights to that? So that has to be considered as well. Are we talking about royalties or one-off payment? All of those things have to be considered. Same with copyright. One particular media or a creation can have various bundles of copyright. So it's not one full bundle. There could be, so for example, in a song, you have the melody, you have the lyrics, you have maybe if there's a video, you have some digital content. So all of that can be split into different types of copyright. Are you assigning or licensing all of that or part of it, and to who? So all of that has to be considered as well. As I mentioned, this would probably be part of another seminar that we might run. But good things to think about for now. All right, I think I have 5 minutes for questions, if any. I think looking at the Q&A, nobody asked any questions, so I would imagine either my presentation was extremely boring or very clear. I hope it's the latter. Tony, did you have any questions for me?
Meryl, it's definitely the latter, and thanks very much for a very clear explanation, which even non-IP lawyers like me can understand to some extent. And thanks very much to all for attending. I think we're going to put the recording on the SICC website for people to review, and very much look forward to the third section. I must say, as a transactional lawyer, I think that disputes lawyers have a lot to pass on in terms of what goes wrong when you're negotiating IP contracts. So I think that would be a very valuable session for transactional lawyers, and look forward to that, Meryl, if you have the time to do that in this series. And thanks very much, and thanks to all for attending, and thanks also to the Drew and Napier Business Services team who have managed to ensure that I didn't make any IT missteps during this recording. Thanks very much indeed, and a good weekend to all. Thanks very much, Meryl.
Thank you, Tony. Thanks, everyone.
Have a good weekend. Thanks. Bye bye.